All right, everybody, welcome to Better Call Paul. Today is Thursday, May 7th, and we have some exciting new stuff for you. With us, we have performance title and escrow and Trident titles, Paul Krasker, with us to discuss the new listing agreement. So if you do not know, the Florida Association of Realtors put a new listing agreement into effect this month, May, and we are going to cover that today. We're going to talk about the changes. There's three major ones. And Paul, I know, is also going to kind of discuss some of the things that we should know and make sure that we're touching on either way. So, Paul, why don't you take it away and lead us through this topic of the listing agreement?
Okay. So the big change, so to speak, is an obligation that you put the listing into the MLS system within 1 business day of marketing the property to the public. That's added in paragraph 5. Paragraph 6A defines what marketing to the property to the public is. That includes, but is not limited to, sending out flyers, yard signs, digital marketing, public-facing websites, brokerage website displays, IDX, VOW, e-blasts, multi-brokerage listing sharing networks, and applications available to the general public. It also includes marketing the property to real estate agents outside the broker's office. Let's talk about why they're doing this. You know, one could argue that they're doing this because they want to make sure that the Fair Housing Act is being followed and that everybody has a shot at looking at the new property. A more cynical view might be to suggest that they don't want people to hold pocket listings forever and market them within their own offices and not put them on MLS and let other people have a shot at them. I think it's MLS trying to stretch their muscle and mandate that people put it on there as soon as possible so that they don't have any other competing websites with their own. That's the big change. Very simple, very easy to understand. What I wanted to do, though, is to just go through the basics of the listing agreement. I have a lot of clients ask questions about a few areas, so I'm not going to go line by line. I'm just going to go to the areas where people have questions. If you do have questions on anything and I'm not covering it, please feel free to text or chat with Ryan or however this technology works.
Yeah, guys, if you can, throw it in the chat, and I will make sure that we ask Paul. So we'll let him get through his basic stuff here and the points that he wants to touch, and then whatever he doesn't cover, we will cover through the chat.
Okay, I'm going to cover the areas of confusion in paragraph 8. I'm also going to cover paragraph 11, which is conditional termination, and I'm going to talk to you about paragraph 12, the dispute resolution section. Paragraph 8, first sentence says, the seller will compensate broker as specified below for procuring a buyer who is ready, willing, and able to purchase the property. Most sellers want to make a change there. Most sellers want to cross out is ready, willing, and able to, and most sellers want to say that sellers will compensate broker for procuring a buyer who purchases the property. They don't want to get into an argument whether the buyer was ready, willing, and able, and whether you owe a commission if the transaction didn't close or not. I represent a lot of sellers, always ask to review this agreement, always make that change, and I've never had a realtor argue against it. So if somebody's pushing back on you with that language, I think it's okay to acquiesce to that language. I also wanted to talk to everybody about paragraph 8D, which is when the fees are due and identifies what the protection period is. People get confused here. There's a blank in the document. I see so many listing agreements come to me for review, and there's still a blank in the document. You have to fill in a date, a number of days after termination, where you'll have a protection period. Obviously, the longer the protection period for you, the better. I've never seen anybody willing to go past past 120 days. That's really not appropriate. And I've seen a lot of people a lot of sellers try to limit that protection period to 30 or 60 days. Somewhere between 60 and 120 is a fair amount of time. And remember, this protection period is for anybody who looked at the property while you had your listing. And what it's designed to do is to prevent the seller at the end of your listing period from simply not responding to an offer and then waiting until after the termination date and then signing a contract with the buyer and eliminate your commission. You shouldn't allow them to do so. I always say the proper thing to do at the end of your termination date is to send a written notice to say, these are the 12 people who I showed the property or spoke to about the property or sent information to about the property, and these are the people who I expect to be protected under the protection period. And just be very clear that if that listing expired without you selling the property, they need to understand in writing from you as quickly as possible that you still expect a commission for those people and lay it out in writing. There's language here that also says that if they relist with another agent, then they're not due a commission. I think you need to talk to your sellers about that and remind them to exclude anybody under the protection period so that you can, yep, Ryan's got it right there, so that you can protect yourself going forward. Does everybody understand that? If you don't, again, chat with Ryan. We could go back over it. The next area I wanted to cover is retained deposits. There's always confusion about that. This says under E that if you don't make any changes to the language and you don't put a percentage in there, you get 50% of the deposit as the listing agent. Now, you'll remember that the standard FAR/BAR contract has in its default provisions that if the seller receives any deposit money and they share it with the listing agent, whatever the listing agent gets, the cooperating agent is entitled to 50%. So if you're the listing agent and you decide I'm going to waive any rights to that commission, the cooperating agent gets zero because you didn't get any money. If you're the cooperating agent and the listing agent is getting 50% of the forfeited deposit, then you have a right to ask that listing agent for 50% of what they got, or 25% of the total deposit. I hope that's clear. Now, there are a lot of times where a seller turns back to the listing agent and says, shame on me for not catching it before. I understand you're entitled to a 50% of the deposit as a commission, and then you have to share that with the other agent. So you decide, if you're going to take that money, I'm going to terminate the listing when it expires. In the alternative, if you want to give me 100% of the commission of the deposit, I'll go ahead and extend your the expiration of your listing agreement to give you another couple months or 6 months or whatever they're willing to give. So that's an item that you can negotiate on, and you as the listing agent are in control of your own destiny. If you don't think you're going to get to sell the property again, then take your 50% of the deposit, share it with the other agent, know you're going to be knocked to the curb when the listing expires. If you think you've got a good chance of selling the property, then certainly negotiate for an extended listing time period.
Paul,
Paragraph
Paul,
11
Paul,
is the,
two questions that came up real quick on that, just while you're on
Sure.
that section. In section
Sure.
9, commission to someone with no relationship to the buyer. Towards the bottom, I think it's line 136, 137. And someone said, can you explain that? What does that mean that they, like line 136, the last piece of cooperation commission?
Yeah. I wish I could tell you. Doesn't make any sense to me. I would cross it out.
So that could that be if a buyer comes to the seller like via an online portal or something, and they don't have a relationship, or they're not, maybe their agent is not a member of an MLS or license, they're just kind of acting as a third party.
Yeah, but I don't think you owe a brokerage fee in that circumstance if they're not representing the buyer. I mean, if the buyer was on somebody else's website and contacted you and didn't disclose their brokerage relationship, that's not fair to you to pay a commission if the buyer doesn't disclose that there's a broker involved and they're represented by somebody. You know,
so in that situation, you would just like run like a strike through
Yep.
After the transaction broker for the buyer starts. So after that semicolon on line 135 all the way through line 136.
Correct.
Okay. And then one other question. Does the buyer's agent have to know, or are they entitled to know, if the listing agent got any of the retained deposit from 8E, 128, 129, 130?
So if the language in the contract stays the same, and I think it's paragraph 15, 15A, lines 330, 331, 332, if that language is unchanged in the contract, then yes, you have a right, you have an absolute right to know if the listing agent received any funds, period.
Got it. Okay, great.
Now,
thank you.
Even if the listing agent, I've had some buyer's agents turn back to my client who was the listing agent and say, I want to see your listing agreement, and that I don't think you need to share. But they're trying to see if that 50% was in the listing agreement, and they're trying to get the listing agent to insist that they keep their money so that the buyer's agent gets some cash out of the deal. But it's very clear that the listing agent has the ability to waive that if they so choose. So if the listing agent wants to do a 0 to try to get an extended listing, or just because they want to maintain their relationship with the seller, they have the right to do that. And the only thing that buyer's agent is entitled to is 50% of what the listing agent received.
Okay. And can they also upcharge that? Like, can they put 100% of the deposit? You know, is that something that's negotiable, that they could just, someone wrote that in the chat, can the agent strike that out, keep 100% of the retained deposit?
Are you talking about in the contract or in the listing agreement?
For 128E.
Okay. Yeah, you can negotiate whatever number you want to put in there. So you can, in the listing agreement, you can negotiate and say, I only want to receive 10% of the forfeited commission, or I only want to receive 30%, or I want to receive 75%, or I want to receive 100%. But if you put in 50%, but at the time of the contract termination and the forfeit of the deposit, the listing agent chooses not to take that 50%, the cooperating broker is stuck with the listing agent's decision.
Got you. So someone answered and said basically it's almost like the honor system. You're saying the buyer's agent doesn't really have the right to see the listing agreement, and they are based on the listing agent doing the right thing and sending it to them.
Correct. But they do have a right to verify whether or not any portion of the escrow funds were delivered to the listing agent. And you can ask the escrow agent and they'll likely tell you, but most times if the listing agent's trying to hurt the cooperating agent, they give 100% to the seller and then ask the seller to write him a check on the side.
Got it. Yeah, I can see that happening. All right, great. Thank you for covering that. So that's 8 and 9. I know you wanted to move to, I think it was 11.
So I wanted to cover the conditional termination as well, because there's a lot of confusion on that from time to time. You get some seller who just gets sideways with you. Most people have to make a decision on how to react and what to do. Up front in the listing agreement, you're always entitled to get your direct expenses incurred in marketing the property. If you paid for advertising, if you paid for signage, if you paid for other things. And then other people put in a cancellation fee of blank dollars, or 1% of the listing price, or something applicable. My experience is it's just a major fight, and that most agents just want to be done with that seller if the seller wants to be done with the agent. And so you might decide to put a 0 in the blank there just to make it easier for the parties to separate. This is what I want to go over with you, because I get a lot of calls on this from time to time when there is a conditional termination. It's always bad faith sellers that do this. They say, I want out, I'm sick of you, you haven't done anything that you said, you didn't properly market it, you haven't spent a nickel on marketing, whatever they're going to say. And they're always saying it because they've got a buyer in the waiting. And they want you to terminate your agreement. And you say, great, there's a paragraph under the listing agreement, it's called conditional termination, and I'm happy to terminate it. Please pay me for my out-of-pocket marketing expenses. Here's a list, here's the dollar amount. As soon as you write me that check, I am going to, as soon as that check clears, I should say, I am going to terminate the listing in the MLS. And then they start screaming and yelling and saying, no, I want a full release from you. I don't want any obligations with you. And I think that's where you need to be firm. And you need to say, look, if you're really being honest and you're taking this property off the market, then it really doesn't matter whether it's a conditional termination or a full termination. But I'm not in a position to trust you, just like you lost trust in me. So if you sell the property during the
Protection period.
Well, it's from the termination date and the protection period, then I'm going to take a commission. So if you're doing this because you want to sell it to your neighbor down the street, and you're trying to cut me out of my 6%, I promise you that's not going to work.
So do you suggest agents have some sort of, I mean, this sounds obvious, but do they have some sort of proof to also show their expenses that are specifically associated with that property? For instance, photography, lockboxes, videography, print marketing, so that they
Me
can...
doy un video aquí para que la gente en la oficina no me vean. Por si acaso se enciende la cámara y me pueden ver.
I don't know what that was. Sorry. So you suggest them having some sort of a way to be able to prove that and not just a guess, so that they can actually collect on that money.
Yeah, it's all direct expenses, so you need to prove it before you're going to get paid a nickel. You need to have your videographer send you an invoice that has the property address on the top and a dollar amount that you paid. And who knows, that seller, if they're really upset, may ask for proof that you paid that, in the form of a Visa statement where you highlight and say, here's where I paid it. and you could white out the personal information above and below that, or a canceled check or some other means.
Someone had said in the chat, if you write a dollar amount for the cancellation, why would you need to prove that? But it's a different expense. Is that correct? One is for marketing and one is for the termination?
Yes, correct. You get your marketing expenses, all direct related marketing expenses, you get them paid for as part of the conditional termination, and you don't have to terminate until they pay you for those. Then there's an additional fee that you can negotiate for. Again, many people put a 0 in there because they're trying to get the listing and they're trying to show confidence in their ability to sell the property. But you may want to put, $1,000. You may want to put $500, whatever you want to put in there. That's where that additional cancellation fee that's separate from the marketing reimbursement is.
Makes sense. So we're thinking one fee is true fixed expenses that would be because of that sale, and the other one is almost like a pain point because you canceled. You're going to pay me something.
Correct.
Okay.
Correct.
Awesome.
So don't just, when people start screaming and yelling, I want this canceled today, and I want a full release, and I don't want a conditional release. That's when you have to lower your voice and speak softly and explain that that's not how this works, and that's not something you're willing to offer, period. And if they do want it, then you negotiate for a percentage of your fee as if you would have sold the property for them. But you really get a good sense of where people are. First they'll start out and say, we've decided to take the property off the market. And then when you say, fine, no problem, I'll give you the conditional termination, there's 3 months left on the listing and we'll just let it naturally expire. But I'll take it out of MLS as soon as you reimburse me for my direct expenses. Then they start getting nasty. Then they say, that's not what I want at all. You've been horrible. I don't want that. I want to list with somebody else. Oh, so you were lying to me 2 minutes ago when you said you were going to take it off the market. Okay.
I can see what's happening.
So the last thing I wanted to talk about is the arbitration provision, and that's in paragraph 12. And I want to remind everybody in line 153, that if you do want to avail yourself of the arbitration right, then you need to initial it, and you need to get the broker to initial it and the seller to initial it. And if you don't, then when it gets time to start whatever dispute resolution, if you want to arbitrate, in all likelihood, the seller is going to say no, just to frustrate you. So if you care about arbitration, and there are pros and cons of arbitration and litigation, then you go ahead and pursue it. But if you don't care about it, then let it go. So here's the upside and the downside from arbitration. If you arbitrate, you pay your own way. It's usually much quicker, and there's usually somebody who has a level of expertise about residential real estate transactions. You're not going to get stuck with some judge who just transferred in from family law or criminal and has no idea about the FAR bar contract, has no idea about the listing agreement. In all likelihood, you're going to get somebody who has arbitrated these issues before and understands what's in front of you. So many people think that they're never going to be unreasonable. So the most logical thing to do is to go ahead and try to arbitrate. Number one, it doesn't run up your legal bill. It doesn't run up their legal bill. You're in front of somebody reasonably quick. You present the opinion, your opinion, the other side's opinion, and then you wait for a ruling. The downside of that is you sort of have to go that on your own. You certainly hire me or somebody like me, but you really don't want to pay the expenses if it's for a commission that's a reasonable number. Sometimes the attorney's fees can jump up too much, and it doesn't make it viable. But again, the other side of that is the seller isn't incentivized to bring their own attorney in either. And if you think you're right on the law, you should get a reasonable settlement or reasonable arbitration ruling. Why some people like litigation is they turn back to me and say, Paul, I'm never going to bring anything unless I'm 100% entitled to it. Therefore, I know when I win in litigation, I'm going to get my prevailing party attorney's fees reimbursed to me. So a lot of people are willing to go the litigation route, willing to pay the fees up front, knowing that they will get reimbursed at the end of the day. I'm an odd duck because I don't like litigation. I don't handle it myself. I have other people in the firm who do handle it. I don't think it's a particularly positive way to spend your life. And I encourage people to try to settle things. And the old adage, a bad settlement is better than a good lawsuit, really rings true for me. So I just wanted to go through all of those options, let you know you have a choice, but you don't have a choice if everybody doesn't initial the arbitration clause. Then it's just voluntary if everybody agrees to do it, if there's a dispute. If you want to know you get to arbitrate, then you really have to make sure everybody initials those boxes up front.
So someone asked if you were the listing agent, what would you do? I think you kind of answered that, but would you want to do arbitration or not?
Yeah, if I were the listing agent, I would do arbitration. I would want it over quick and easy. I wouldn't want to be funding my own legal fees. I wouldn't want to be responding to depositions, to interrogatories, to requests to produce. I wouldn't want to be going to hearings and sitting in a courtroom waiting for a judge who may or may not understand the legal issues that you're presenting to them.
Makes sense.
So but if you feel very strongly about it, you have the money to litigate, and you think it a matter of principle, then litigation gives you those prevailing party attorney's fees if you are victorious. Obviously, collecting them is another story, but at least you get them in your judgment.
Yeah, that makes sense. Okay, a couple of questions about the coming soon. So one said, do these new updates make pocket listings illegal, or are they just making them where you're essentially having to disclose to the seller that you are or are not marketing it on the MLS?
Yeah, so if it's truly a pocket listing and it sits in your pocket and you do no marketing, and you tell one or two agents who you know work in that price range and work in that neighborhood, then I think you may be able to exclude your circumstance, but I think that's what the coming soon is trying to do, is get things on MLS so everybody can see it, but not have people traipse through the house immediately and not have an obligation to have your videos and your photos done just that moment.
Understood. So it keeps coming soon alive, just in a way that is public knowledge, essentially.
Yeah, and you look at this, the market the property to the public doesn't say that you have to do it. Actually, it probably does when it says marketing also includes marketing the property to real estate agents outside broker's office. So if you knew that an agent with Palm Beach Polo was had some people who were looking in a subdivision, and you signed a listing agreement up and the people said, yeah, but we don't want to show it until October. We're getting the house painted this summer, or whatever they're going to say. If you start telling the people at Palm Beach Polo that, hey, by the way, I have this, then the language in paragraph 6A2 would obligate you to put it into the MLS.
I'm going to share 6A2 just so everybody sees that real quick. So 6A2, public marketing also includes marketing the property to real estate agents outside broker's office. 6A2. Okay, someone else said, can they get around that and market the property before listing by putting it in the additional terms that the seller agrees to allow the agent to do so?
You mean put in the additional terms that
like for instance, a lot of agents
that
would say, they take the listing today, they go on the appointment at Paul Krasker's house today, and you say, yes, you're going to agree for the listing, but they'll put in the additional terms, marketing date to be 2 weeks from now, that the official marketing date is going to be then. So the seller does know it, that they have X number of days to be able to put on the market, but it's not on the market now because they're painting the door and staging and whatever.
I think that needs to go into the coming soon area if you're going to do that. Remember that your relationship with MLS as an agent is different than the seller's relationship with MLS. The seller doesn't care at all about MLS, but to some extent your livelihood is benefited by MLS, and you don't want to be sideways with their rules.
Makes sense.
Go ahead.
Let me see if anybody else. I think those are all of the questions. If anybody else has a question, throw it in the chat. Someone said in the chat, I thought I read in the email could only be coming soon for 21 days. She said that was from the email that went out. I'm guessing the one from the board.
Yeah, they've given us their cheat sheet for the information, and I didn't see the 21-day time period.
I'm looking for that too now.
But there may be some other rule that's already in existence that says you can't do coming soon for more than 21 days. I just never heard of that time period before.
Yeah, they're updating that, and they are sending out some blasts and whatnot. There's also going to be, I believe, like a town hall kind of thing coming up. Someone said that it pops up that the max days is 21 days from the time entered. So kind of like the default situation on the MLS is when you go to put it in, that it only allows you to add, a time frame of 21 days.
And it makes sense from MLS's perspective. They're trying to get as many people in the world to see it on their website, and they're competing with other technologies, and they want to make theirs the preferred technology.
Paul, can you see my screen? I just pulled up the
Yep.
thing from the MLS. So a listing can only be in the coming soon status for up to 21 days. Once the listing is coming soon, the go active date can only be modified by the staff, meaning the staff of the MLS. Photos are not required. So those of you guys, if you recall, you used to have a photo in the MLS within 24 hours of it going live. In coming soon, you do not have to do that. Days on the market will not count, so it will not count in your cumulative MLS stats. Showings and open houses will not be permitted. $1,000 fine if it's in coming soon and you show. Once active, a listing cannot change back to coming soon. Listings can be changed to cancel, withdrawn, temp off the market, or close, rented. Listings will not automatically syndicate during the status, so they will not go out to Realtor.com and Zillow. However, you can opt in, so that's the same as when you always put in a listing in the past. And listings will be included in broker websites, so IDX, stat reports, and all those fun things.
So if you do put it in coming soon and somebody calls you and begs you to show the property because they want to buy it today, you have to turn it active
Instantly switch it to active. Yep.
to avoid the $1,000 fine.
Yep.
Okay.
All right, guys. Thank you again, Paul, as always, for being on here. We appreciate you guys. For the rest of you, if you have not already seen and figured out our schedule here, it is every Thursday. We're going to be rotating topics throughout the month. Later in the month, we're going to have 2 live question and answer sessions, as well as be covering a quick overview like we did today of the as-is contract. So make sure you guys tune in for that. Thank you again, Paul Krasker, for being on. We appreciate you. And if you guys need anything, please reach out to Paul Krasker or Trident Title, as well as Performance Title and Escrow. And please keep sending us deals so that we can keep these things moving on. We appreciate it.